Hello everyone. Today in this video I am going to discuss about section 121 of the Companies Act 2013 that deals with report on annual general meeting. As you can see my earlier videos, I have already discussed about the provisions of annual general meeting to be complied with by the companies, whether private, public, listed companies, all kind of companies, the provisions that need to be required to be fulfilled with respect to annual general meeting. I have already discussed it in my earlier videos. Okay, so today I am going to discuss only about the report on annual general meeting and what all are the companies that needs to give this report on annual general meeting, what should be the content of this report, and who shall sign this report, and in how much time it has to be filed with the registrar of the companies. So let's move forward and discuss one by one the topics regarding report on annual general meeting. So first of all, as you can see that section 121 provides about the report on AGM, and section 121 subsection 1, it requires that all listed companies have to prepare this report. Okay, so only listed companies are required to prepare this report and in the manner which is prescribed in the rules. Okay, I'll be discussing it later on in my slides. So now it says that this report is in addition to the minutes of the meeting. Every company has to prepare the minutes of the meeting, but apart from that, a report is also need to be prepared by the listed companies, which is on the AGM. Okay, and it is given under section 121 subsection 1. Correct. Now, it has to include the confirmation to the effect that the meeting was convened, held, and conducted as per the provision of this act and the rules made thereunder. So basically, this report, it should tell that all the provisions with regard to the meeting which is given under the act or in the rules have been complied with, and it has been convened as per those provisions only. That is, meeting has been convened as per those provisions only. So this confirmation is to be given under the report. Now, as I mentioned that the prescribed manner which I have read it in my first point, it is given under rule. Which rule? It is given under Rule 31 of the Companies Management and Administration Rules 2014. Now, what does this rule says? I'll be discussing it. So let's move forward. Okay, so now Rule 31, Sub-Rule 1 and Clause C and D, it provides the contents of the report. Okay, now what does the contents mean? Which is what all details have to be included in this report. It is given under Rule 31, Sub-Rule 1 and Clause C and D. Okay, so now it says that the day, hour, venue of the AGM has to be disclosed. The details has to be disclosed. So first point is day, date, hour and venue of the AGM. Correct. Secondly, confirmation with respect to the appointment of chairman of the meeting, whether the chairman has been appointed, who has been appointed. So all these details have to be disclosed in the report. Correct. Thirdly, number of members who are attending this meeting. Okay. Fourthly, so you can see all are the basic points, but they have to disclose, which is the requirement of the section 121. Okay, and what are the contents? They are given under the rule. So now it says the fourth point is confirmation of the quorum, whether the quorum was present or not, and the actual quorum was present, or there was a shortage of the quorum, or whether the meeting was adjourned because of the want of quorum. So all these details have to be mentioned. Another point is confirmation with respect to the compliance of the act, rules, secretarial standards made thereunder with respect to calling, convening, conducting the meeting. I have already discussed that the report has to include the confirmation that this meeting has been convened and held as per the provisions of the act, rules, secretarial standards. Okay, so this confirmation is to be provided in the report of the AGM. Okay, by all the listed companies. Now, what is the business that is transacted at the meeting and the result thereof? What was the result, whether it was passed by a requisite majority or not? Then particulars with respect to any adjournment, postponement of meeting, or change of venue. So I have already discussed, if this adjournment, postponement of the meeting is being done or the venue is being changed, then that is also to be disclosed in this report. Another point is any other points relevant for the inclusion in the report. Okay, so if there is any other point which needs to be disclosed in this report, then that is also to be mentioned. So now these were the points which were provided in the Rule 31 Sub-Rule 1 and Clause C. Now one point is given under Clause D, which says that the report shall contain fair and correct summary of the proceedings of the meeting. Okay, so what all the summary of the meeting, proceedings of the meeting, uh, it is to be mentioned in the report, and the fair and correct summary has to be provided. Okay, so I think as of now it is clear. It's a simple concept and is applicable only for the listed companies. Now, moving forward, who shall sign this report? The question arises. Now, Rule 31, Sub-Rule 1, Clause B provides the signing of this report. So, the signing has to be done. Signing and dated. That is, the date is to be filled by the chairman of the meeting, or in case of his ability, like suppose he is not able to sign that report, by any two directors of the meeting, one of whom shall be the MD if there is one. So first of all, it has to be signed and dated by chairman of the company. If he is unable to sign and date that report, then by any two directors of the company, one of these director has to be MD if the company is having one. Okay, so if there is no MD in the company, that only two directors signing the report would be sufficient. Only on the inability of the chairman to sign the report. Okay, now, and. So here the word used is and, which means apart from this, company secretary of the company also has to sign this report. Correct? So let's move forward. Now, we shall discuss about the filing of this report. So as we know that section 121 also provides about the signing of the report. Apart from the signing, filing of this report. Okay, so in rules, signing of the report is mentioned, and in the section, filing of this report is mentioned. So this report has to be filed with the registrar in form number MGT 15 within 30 days of the conclusion of AGM along with the fees. So this requisite fees, along with this fees, the report is to be filed with the registrar, and which is the form MGT 15. It is given in the rules. And within how many days? Within 30 days. Now, within 30 days of the conclusion of AGM. Correct. Now, why I have highlighted this term? It is just because the act is mentioning about the conclusion of AGM, and it is not talking about the due date on which the AGM should be held. That is the last due date on which the AGM is to be held. Okay, so 30 days is to be calculated only after the conclusion of the AGM. So suppose a company is not able to hold its AGM, then the contravention of this section would also be applicable. I think I am making myself clear that here it is talking about the conclusion of AGM. So suppose if the AGM is not concluded, then this 30 days, it cannot be counted, correct? The report cannot be filed. Okay, and if the report cannot be filed, then the contravention of this section would be applicable. Now let's move forward. It says that what are the provisions of the punishment or the liability in case if there is contravention of this section. Now suppose if the company fails to file the report before the expiry of the said period, now 30 days is given under the section, and under section 403 it says that within 300 days along with the additional fees a company can file its form. Okay, so within those 300 days, if the company is not able to file its report on AGM, then the company shall be punishable with the fine of at least 1 lakh rupees, which can extend up to 5 lakhs, and every officer who is in default he shall be liable with the minimum liability of 25,000 rupees, which can extend up to 1 lakh rupees. So I hope I have made myself clear with regard to this topic. And if you have liked my video, then please like and subscribe. My YouTube channel is PH Webgyan Videos, and please do not forget to share and comment on this video, as your comments are valuable, so please do. Thank you.